necessary.
That's right.
So therefore, they said that, all right, we are now going to replace the word Constituent Assembly by the word Legislative Assembly, which they sought to achieve by amending the Constitution.
No, it's a recommendation of the Constituent. It's not
Yes.
just converting it. You can't.
The first step was to amend the Constitution.
Yeah, you recommend it to yourself because you have a political objective to recommend it, and Mullahs, you take the decision yourself.
Yes.
This is a very problematic, Mullahs. And see the consequences of this. That means through an executive order, you can change any provision of the Constitution because you have majority. But this majoritarian culture cannot destroy the edifice of what our forefathers gave us.
So your argument, therefore, is that you cannot exercise the power under 356 to amend the Constitution.
Exactly.
That point you...
That's right. And they cannot possibly justify it unless there is some new jurisprudence that comes to light that they can do what they like as long as they have the majority. As it is, Mullahs, now one of your esteemed colleagues has said, Mullahs, that in fact basic structure, those theory is also doubtful. Maybe it is.
If we refer to a colleague, we have to refer to a sitting colleague. Once we cease to be judges, they are opinions, not binding diktats.
That's true. Of course, it's not binding, but I'm surprised.
On 11th of November 19...
Parliament doesn't discuss what goes on in the court.
No, I'm not discussing anything.
I am not discuss what goes on in Parliament.
No, I'm not discussing.
Everyone, my lord, has a freedom
this is a public
freedom of expression.
No, I know. But I assume he has the freedom of expression what he likes. I don't dispute that. I'm just saying, Mullahs. Of course, absolutely. We're starting a debate on that because of this majoritarian culture again. I said that 356 was already in place.
Mr. Sibal is responding to the parliamentary debate here because possibly he was not there in the Parliament yesterday.
That is true. That is absolutely true.
It was that place where he could have learned.
You are right.
Expressed his views on basic structure.
Not my view. I'm not. My view is clear because my view is the court's view. I can't go beyond that. But I am an officer of the court. In court, I have that constitutional view. Outside, may have a different view. Anyway, that's neither here nor there. It's just an aside. But there must be some element of humor and mirth in court as well. Not everything can't be this serious.
Yes,
therefore, see the consequences of this. And then it is obviously clear that the government of India and Parliament recognized that the Legislative Assembly was the Legislative Assembly and could not be the Constituent Assembly, which is my interpretation. Therefore, it became necessary because they also knew that the Legislative Assembly can't be the Constituent Assembly. That's precisely what I've been arguing. And it says shall read. This is an interpretation clause. Please appreciate 367 is an interpretation clause. It's not a clause to substitute definitions. If you look at 367, the heading is interpretation. It's not substitution. You can't substitute definitions. You can only interpret. So it's outside of 367 itself, apart from many other things that I've pointed out.
What they've done is they banned it.
Yes.